Hello everyone, and hope you're having a beautiful day. Well, today's session is a continuation to our video on general exceptions, where we have discussed the first five general exceptions, and today's video we are going to specifically be focusing on the following sections which are mentioned on this slide, which are duress, consent, communication, trifles, and private defense. Well, let us get started and move on to our first exception for this session, that is duress. Section 94 exempts a person from criminal liability in respect of an act which is committed under compulsion or duress. Now, if we look at this maxim which says actus ne invito, factus est nisi actus, which means an act done by me against my will is not my act. Well, this very nicely sums up the very gist of the exception of duress. Well, we have two exceptions, and these exceptions very clearly tell us two acts which can never be done even in order to save your own life. That is murder, which means that you cannot take somebody else's life in order to save your own life. Other than that, any other act which is forbidden by the IPC except murder, if it is committed by you under duress, you can avail this exception. But if you kill another human being in order to save your life, then law and this exception will not be able to save you from criminal liability and penal consequences. The second act which you cannot do even in order to save your own life is waging war against the government of India, or in other words, indulging in seditious activities. Moving further, next exception is consent. Well, section 87, if we look at the slide, is giving immunity from criminal prosecution on the ground of consent in general. So, section 87 is generally explaining us the exception of consent. It lays down that immunity will not justify causing death or grievous bodily injury or harm likely to cause death, which is known to the doer. So, if a person gives you a consent to do an act, but if you know that your act will lead to the following, that is cause death or grievous bodily injury, or will cause such bodily harm which will eventually lead to a person's death, then you will not be able to avail the defense of the exception of consent because you knew what the implications would be. Now, if you look at this case, ex Bonais Fatima's case, let us read the facts of the case. The accused was a snake charmer, and he persuaded the deceased to be bitten by a poisonous snake. He induced him to believe that he had the power to protect that person from any harm. Now, the accused could not save the deceased. Now, the deceased's consent did not excuse, in this case, the snake charmer from being excluded or from escaping criminal liability, because when he induces the other person to be bitten by a poisonous snake, there is sufficient knowledge on his part to be very clear that this act will lead to the death of the deceased. So that is why this is very crucial, that if you know your act is going to lead to eventually the death or straight away the death of a person, you will not be able to avail this exception. Section 88, 89 and 92, they are extending protection in those cases where harm is caused in good faith for the benefit of the consenting party. Section 88 is basically the very basis of medical jurisprudence these days, because it is granting immunity to people like doctors from punishment for all acts. But again, they cannot cause death intentionally by taking up the defense of this section. Now, our next exception is communication under section 93 of the Indian Penal Code. Now, under this exception, what is done is a person is saved from criminal liability if the person makes any communication for the benefit of the person to whom this communication is made. Two very important things that must be kept in mind is that the communication should be made in good faith, and secondly, this communication should be made for the benefit of the person to whom a thing is being communicated. Let's look at the illustration. A doctor who is communicating in good faith to his patient about the gravity of his disease and the probability of his living, and as a result the patient dies of shock. In this case, of course, the doctor is making the communication in good faith, and it is extremely important for the benefit of the patient to know the gravity of the disease and the probable lifespan that is left with him. Now in this case, the doctor can avail an escape from criminal liability by taking up the defense of this exception. Now this is an extremely important case, X versus Hospital Z. In this case, what happened was the doctor disclosed to a prospective bride the fact of HIV complaint of a proposed bridegroom. Now, in this case, the doctor is making the communication in good faith, and it is extremely important for the benefit of the prospective bride in order to know about such a grave medical history of the prospective bridegroom. Moving further, our second last exception is trifles, and the maximum of de minimis non curate lex, that means law will not take care of trifles. Trifles are insignificant or not very important acts. Section 95 prevents a person from being penalized for indulging in trivial or insignificant acts like a soft nudge from the elbow, or if someone throws a pencil at you. The law will not pay heed to such complaints. Now, even though such acts are falling within the letter of law, they are not punishable within the spirit of law, because these acts, due to their triviality, are considered innocent. Private defense is an extremely important exception as far as the Indian penal is concerned. It is a full-fledged topic which requires a thorough study in itself. We are going to try to understand private defense from a very basic perspective. Now, this exception is based again on the rule of preservation, so you can very easily supplement the exception of private defense with the exception of necessity that we've just discussed. Now, this right is important for the protection of one's life and property. Hence, Indian Penal Code is giving you a right to defend not only your life but also your property. Now, it allows the use of necessary force against the assailant or wrongdoer, and such a use of force will be legally permissible when immediate state aid cannot be procured. So there are certain things we can very clearly deduce from these lines. First of all, necessary force means that the proportion of attack and the proportion of self-defense must be equal. Your self-defense or private defense must never exceed the attack. So if someone is simply attacking you by giving you a blow on your face, it will be unjustified as a reaction if you shoot the person, because the proportion of attack and the proportion of self or private defense will be extremely disproportionate. Secondly is that it is always available against the person who is attacking you and no one else, and you will only be allowed to exercise your right of private defense if you cannot call out for help to any state authorities. Section 100, 101, 102, 106, they deal with private defense of body, and section 103, 104, 105, they deal with private defense of property. Moving ahead. Now, in what situations will the right of private defense not be available? Well, the first situation is against the acts of a public servant who are acting in good faith. Then again, against the acts of those who are acting under their authority and direction. By their authority, I mean, of course, state authorities, public authorities. And where there is sufficient time for recourse to public authorities, like I mentioned in the previous slide, if you have the time to take recourse to public authorities and their help, then you should not exercise your right of private defense. And the quantum of harm that may be caused shall in no case be excess of harm that may be necessary for the purpose of defense. So only apply necessary private defense, necessary harm. So in order to avail the exception of private defense successfully, never apply any sort of force which exceeds the attack while exercising your right of private defense. Now let's look at the case on the slide, Jaipal versus State of Haryana. It's a 2000 case. The accused was harmed with a deadly weapon and the victims were without any arms. So if you're exercising your right of private defense by using deadly arms against attackers who do not have any arms with them, in that case you have clearly exceeded your right of private defense and you will not be able to escape criminal liability for your act by taking up the plea that you did this act in order to preserve yourself or to uphold self-preservation. Now, there are certain situations which have been enumerated under section 100 which clearly tell us that under what situation can you go up to the extent of causing the death of a person while exercising your right of private defense. Well, when an assault which causes reasonable apprehension of death, or the assault causes a reasonable apprehension of grievous hurt, or it causes a reasonable apprehension, or there is an attempt of rape being committed, or there is an attempt of gratifying unnatural lust, or of kidnapping or abduction, or of wrongful confinement. Hence, I'd like to suggest that you analyze and understand this slide very carefully, because while solving your legal principle and fact questions, it is very important to have these 6 pointers in your head in order to justify whether the private defense's plea can be successfully taken up or not in case the person who is exercising private defense causes the death of the attacker. So if the assailant's act falls in either of these 6 categories, you will be able to successfully take up the defense. Now the next slide is telling us as to when you can exceed your right to private defense to property to the extent of causing the death of an assailant. Well, in the following 4 situations, you can cause the death of an assailant in case the assailant is attempting robbery, or there is house breaking by night, or the assailant is causing mischief by fire, or there is theft, mischief, or house trespass. Hence, in the following cases, a person will be allowed to exercise private defense, and while doing so, if the person causes the death of the attacker, he or she will be able to successfully take up the plea of this exception and escape criminal liability. With this, we have finished general exceptions under Chapter 4 of the Indian Penal Code. In case this has been your first pick, then please watch the other video which is dedicated to general exceptions under the IPC, as both of these videos cover the topic in halves. I hope this video session was insightful. Have a lovely day. Thank you very much.